Let's bring in trial attorney Michael Jaafar. So hard to see. And Michael, you know, typically I think when we think of victims, we think of family members, fiancés, boyfriend, girlfriend. But here is a case, I have no doubt, that the friends of Megan, that they'd known, for instance, her since 5th grade, are victims in this case. They knew Evelyn. It looks like they'd bonded with Evelyn, had a relationship with Evelyn. And she says to her, send me pics. And guess what? Megan never sends pics, and now she knows why. She's accused of killing her. We know Evelyn's dead. How do you think the state is doing?
I think the state is doing fantastic, and its exhibitions of emotion like this is why I send my heartfelt thanks to all of our colleagues who do criminal defense cases. We're grizzled veterans, right? So we're in this industry and we understand how it goes. And even us, a part of your soul dies when you look at this case. I noticed that even the judge's head tilted down during this, couldn't look up because of how awkward it is, how sad it is. I think the state is doing a fantastic job. Obviously, they have to bring in this witness. The judge had to allow it. They're doing a fantastic job at showing the trauma that was caused by her deception, by her lies. At the end of the day, she has a defense. They're going to come at it from the way that we know that they're going to come at it, and they're going to say this was not intentional. She was lying after the fact. She was nervous. She was broken. But at the end of the day, whenever you can paint the defendant as a villain, whenever you create somebody into a lying monster, it always benefits you as a state. I'm not saying that the mother, that the defendant is a lying monster. Maybe she is, maybe she isn't. But at the end of the day, this is there was already an overwhelming burden for the state, for the defense to cross over. Those tiers just added 10 feet to the pile. I mean, it's very difficult for them at this point.
Yeah, Mike, I couldn't agree more. And you're right. The question in this case is she a liar or isn't she a liar? And I was talking to Judge Ashley saying, you know, is it possible that this was a Sid's death and she just, as a young person, wasn't ready to tell that story? But when you see all these friends coming in and she's lying to them, not telling them or confiding in them the truth, seeing how much they seem to care about Evelyn, I think it makes it more probable that she's just lying.
There are only two universes in this case. There's a universe where she did it intentionally, and there's a universe where she didn't do it intentionally or the kid died on her own, right? We don't know which universe we live in. It would be a tragedy if we live in the universe where she did it intentionally and she gets acquitted, or she gets a reduction to manslaughter, or vice versa. Either one would be a tragedy. The purpose of this case, obviously, to see it through. Lying after the fact, look, there's a lot of people who lie and it starts in their childhood, right? There's a situation where she did not do this intentionally to her daughter, but she was abused as a kid and she learned how to lie. Lying is something you learn as a kid. There's people who never lie when they're adults because when they're kids, there was no consequences if they were troublemakers. And then there were kids that would be beaten and abused, and they grow up and they lie about anything. So we just don't know. It's tough. It's very, very, very difficult.
And we do know that according to the ME, she had an obstruction in her airway in the form of foil, and then there was a blanket tightly wrapped around her head, and that in the trash can is another form of asphyxiation. So, you know, it could have been she choked on foil.
She could have choked on foil, but I think that's probably where they're getting the premeditated murder.
Yeah.
The first-degree murder, right?
Yeah.
Because could possibly be she put it in there.
Yeah, also 2 counts of felony murders, 20 counts in total she faces. All right, we understand we're ready to go back inside the courtroom.
Let's bring back in trial attorney Michael Jaafar to discuss. A quick note, that would be the end or very close to the end of her direct examination. She'll be back on the stand tomorrow for cross beginning at 9 a.m. Michael, quickly, we're hearing a lot of information clearly about the lies, et cetera, et cetera. What we're not hearing a lot of is the fact that she was a really bad mother, and that, you know, those are the things as well that could lead a jury to believe that she could do something like this to the child. We're not hearing a lot about neglect, although she is charged with that. We're not hearing a lot about any kind of abuse, although she is charged with that as well.
I was thinking on the break, during the break, Michael, because I agree with you. I was thinking, you know, maybe the defense would have fared better by just waiving the jury. This is too inflammatory. All these inflammatory pieces of information, I think the stuff we haven't seen or heard yet, we're going to hear throughout the balance of the trial. Maybe they should have just waived the jury, right? Because at the end of the day, they could have, when the defense takes the case, they can bring on an expert and say she was nervous, she was lying. If, you know, had she really done this intentionally, she would have never thought she was going to get away with it. Maybe she was just trying to delay. You know, from her childhood, she was abused, yada yada yada. I think they would have just been better off just waiving the jury, because at the end of the day, we're not hearing any of that stuff, even though all that stuff is relevant. And the way you've explained it, the jury is, by the end of this case, the jury is going to hear all of that because she's charged with more than just 1 or 2 or 3 crimes. At the end of the day, I don't see how a jury is gonna acquit her or bring down the charges to manslaughter. It's too inflammatory. They passed a law in that state because of her conduct. The law has been changed. It's just a completely inflammatory situation. The deck is so stacked against her so thoroughly. It's not like she has a winning hand either way. I feel like you're better off with the trier of fact being a grizzled veteran judge. That's just my opinion.
Especially because, to your point, there are 20 charges. We know she's been charged with first-degree murder, 2 counts of felony murder. The underlying felony are counts of aggravated child abuse, aggravated child neglect, tampering with evidence, 12 counts of a false report, abuse of a corpse, and failure to report a death under suspicious or unusual circumstances. They're throwing the book at her in terms of all the charges they can stack against her. That's a lot for any jury to sort through.
And the jury won't do it because we know that juries are comprised of human beings, not robots, and so they're going to gravitate towards the inflammatory. There's too much inflammation in this case. There's too much inflammatory content. There's a lot of people in the jury who'll say, I would never do this. I would never do something like that. I mean, and they would be right? A reasonable person wouldn't do it. But when you have a grizzled veteran as a trier of fact, I'm not saying you have a slam dunk. Either way, the deck is stacked against you, but you just have a little bit of a better, like a person who's seen these fact patterns for decades, right? Because the judge doesn't look like he's 20. Looks like he's the type of person who's seen these types of grotesque fact patterns either in his cases or in his courtroom for decades. And so you just have a little bit of a better shot at having that grizzled veteran peer through the inflammation and just maybe make a better decision.
All right. Thank you. It does make sense. Thank you so much, Michael Jaafar, for joining us. And Michael, grizzled veteran may be a new term I can use with all the experience and expertise. What do we have coming up?
Fair enough. All right.